Let's talk about the stages of a criminal case. So they really vary between a felony and a misdemeanor charge. Those are the two charges that criminal cases in Colorado break down into. Most criminal cases, there can be lesser offenses like petty offenses and traffic charges. But for the most part, when we're talking about a criminal charge, it's going to be either a felony or a misdemeanor. Misdemeanor charges are more or less defined as charges which carry a penalty of less than 1 year in the county jail. Felonies are charges that carry a year or more in prison. And if you want to know the distinction between a misdemeanor and a felony, it's the penalty for a misdemeanor is jail, right? The penalty for a felony is typically prison. Now, that's not the case for every single charge. There are some felonies that start off at a minimum of 6 months and go up to 18 months. And there at least used to be, the law recently changed, but there used to be certain misdemeanor charges which carried a possible penalty of up to 18 months in jail. So the law hasn't always used that as a bright line rule, but in general, if you want some guidance about if you're being charged with a misdemeanor or felony, look at the possible penalties. That'll give you a pretty good indication of where things are. So misdemeanor charges typically start off with a summons. What's a summons? Well, a summons is an order to appear to court on a specific day to be advised of the charges against you and answer for those charges. It's different than a felony case, which is typically started by an arrest occurring and then a person needing to post bond in order to get out of custody, at which point they're given their next court date. What's the justification for that? So in general, the justification is that misdemeanors are less serious than felonies, and because of that, the idea is that people would be more prone to abscond from the state to avoid a felony charge or felony conviction than they would for a misdemeanor. So the reason that our bond system started was to make sure that people would have an incentive to make their court appearances in the future by requiring them to post an amount of money that would incentivize them to come back and make their court appearances. Is that still the case? Not really. With the existence of bond people who are willing to post a bond for typically around 10% of the actual bond's value, the incentive structure is a bit more perverse than it was at the beginning when these things were instituted. There's also a lot of recent studies showing that certain pretrial monitoring systems are just as effective at making sure people make their future court dates than a monetary bond. Regardless, that's why the system came into place, and that's why it exists to this day the way it does. Now, when a felony case is started and somebody has to post bond, the very first court date is a bond advisement hearing. That's where a judge will tell somebody who's in custody what the charges are against them, the possible penalties that those charges carry, and they'll let them know the amount of the bond that they'll have to post. And that also allows for certain arguments about bond, and then they'll advise them of any protection orders in place. Now, it doesn't have to be a district court judge who does that bond advisement. A lot of times it's a county court judge or even a judicial magistrate that does that initial advisement. After that, the next court date that somebody charged with felony is set for is what's known as a filing of charges date. This is because the district attorney's office will review the charges that somebody was arrested for and then make a determination on what charges they're actually going to go after when they're prosecuting that person. That's important to remember, because just because you're arrested for a specific charge, that doesn't mean that ultimately those are the charges the DA is going to pursue. They can pursue additional higher level charges, more charges, or lesser charges. So that's what the first appearance date is about. And if the system's working properly, the district attorney should be acting as a screening mechanism to prevent cases from proceeding forward in front of a district court judge if there's not at least probable cause to support those charges, but ideally and frankly ethically, evidence sufficient to support a reasonable likelihood of success at trial is the standard that district attorneys have for the cases that they're going to pursue. So after first appearance, your case is either then set for an arraignment or a preliminary hearing, depending on the level of the charge and whether or not you're in custody. A preliminary hearing is a screening tool that's in place to evaluate whether or not the district attorney has probable cause to continue to pursue the charges against you. A person's entitled to preliminary hearing in Colorado if they're incarcerated on any felony charge, if they're facing a Class 3 felony offense or higher, or if the offense that they are facing requires mandatory incarceration upon conviction. The reason for this is that the courts want to screen out frivolous charges, especially for people that are going to be faced with a mandatory sentence upon conviction. And even when you have somebody who's out of custody and they're not being continually deprived of their liberty while the case is pending, certain charges that are Class 3 felonies and above carry a large enough stigma attached to them that just the accusation of certain crimes can be enough to severely impact somebody's life. And so this screening procedure is set up to prevent cops and district attorneys from filing really baseless charges against somebody and having that go through the entire process without a gatekeeper filtering those while the case is ongoing. Now, if you don't have one of those charges, then your case is set for arraignment. Or if you do have one of those charges and you go through preliminary hearing, the next court date is arraignment. Arraignment is a date for a criminal defendant to either decide to take a plea. There's typically a plea bargaining process and a formal plea agreement that will go into place at that date and the case is resolved. Or if the case has not reached a plea agreement, then that's the date for a defendant to enter pleas of not guilty to the charges against them and set the case for trial. Now, it's important to remember that during this whole pretrial proceeding, right, before we get to arraignment and enter not guilty pleas, there has not been a running clock for your speedy trial right. Now, that clock only gets started once you pled not guilty, and then it becomes both the judge and the district attorney's obligation to take your case to trial within 6 months of the date that you plead not guilty. Now, it's a Colorado rule. That's not everywhere. There is both a U.S. constitutional right to a speedy trial that you have, but Colorado also has a specific and more stringent speedy trial right. While the Constitution says that your trials shall be both public and speedy, Colorado gives that an exact definitive figure of what a speedy trial right looks like, and here we've said that that means 6 months from the date that you plead not guilty. Now, once you've pled not guilty and your case is set for trial, then you have the ability to take to the judge any motions issues that you think are appropriate. So those can be things like motions to suppress evidence of an illegal search, or motion to suppress statements that were done as the result of a coercive interrogation. It can also be just basic housekeeping procedures to address accusations that are unrelated to the case and to keep out what's known as 404B or extrinsic evidence from the trial, and any kind of motions in limine about how the trial is going to be conducted, what specific evidence is admissible, demonstratives, and those kinds of things. Now, after a motions hearing, and that motions hearing does not happen in every case, but you are entitled to one in every case. After the motions date, the next date is typically a date for trial readiness or status conference. That's where both parties to a case will show up and say if they're going to be ready to proceed to trial at the actual trial date. There's a lot that can come up between when you plead not guilty and when your trial date is scheduled. Witnesses can become unavailable, or you may need additional evidence, or to do an additional investigation, or to file an additional motion that came to light later on in the case. So that's why the courts do these pretrial readiness or status conference dates, so that they know that when they're calling in a jury, they're actually going to be ready to proceed to trial on the trial date. The last part of a criminal case is the actual jury trial, and that starts off with bringing in a number of potential jurors. They're called the jury veneer, and paring that down into the actual jurors who will be on an individual case. And then the trial proceeds from there with both sides doing opening statements, The district attorney then launching into their case in chief and presenting the evidence that they believe is necessary to prove the charge beyond a reasonable doubt. The defense cross-examining those witnesses, and then the defense presenting their case if they have one. The case ends with closing arguments by both parties, the district attorney, then the defense, and with the district attorney having the last word, meaning the last opportunity to rebut any closing argument presented by the defense. And the reason that they're given that opportunity is because they have the burden in a criminal case. Following that, then jurors are sent out to deliberate, and they can take as long or as short as they need to deliberate and come to a verdict. If they are able to come to a verdict, then the judge will bring the jurors back in, take their verdict, and guilty or not guilty, that's when the case is resolved during the initial proceedings. And then if there is a guilty verdict, there can be additional proceedings for an appeal.